during these series of virtual meetings. We thank you for the efficiency with which the deliberations have proceeded. Continue to sustain us in the work that we all do. We pray that the NITS will benefit our nation and help us to create a more equitable and just society. Keep us and our families in your care always and uphold us with your strength. In Jesus' name we pray. Amen.
Thank you very much, Minister Marsha Smith. Any apologies, Anila?
No, Minister, I haven't gotten any.
Okay, so colleagues, I'm going to ask Minister Camina Johnson-Smith to take over. We're going to do clauses 28 to 38. I will rejoin you hopefully within half an hour. So I'm going to sign off now because I'm going to be joining another Zoom meeting. So Camina, kind of take over. Thanks again.
Will do, Minister. Thank you. Let me just check if Ms. Facey, you're on the call. Are you going to guide us through? I'm seeing on my list of participants, technical team. Yes, Ms. Facey. Okay, you have changed your name now. Just checking that you will be leading us through the matrix, which was circulated by Ms. McCarthy yesterday afternoon.
Yes, I will.
All right, excellent. Thanks. Please go ahead. Please start us. Thank you.
Okay, good morning, everyone. Right. So I have put up for our information the national identification and registration. All right. Right, so this is the matrix for today, and we had stopped at clause 20, pardon me. Right, okay, so we had stopped at clause 27, so today we'll start at clause 28 as it related to the special provisions in respect of offenses. There were no submissions made that warranted any change.
Ms. Facey, just 1 second.
You're not hearing?
I'm hearing, but didn't we stop at 25? And I don't know, because we never did 26. And I got the impression that we were just going to 28. Did we do 26?
No, we didn't do 25 and 26. Those are scheduled toward, right.
Okay.
Right, to be done with the schedules that are applicable to them.
Very well.
Okay, right. So 28, there were no submissions that require any modification. The only submissions were really as it relates to or emanated from other clauses, which would trigger this clause by virtue of the fact that the offense, the penalty for the offense would not be stated here. So the special provisions in respect of offenses clause really speaks to or provides that there will be a $1 million penalty in the parish court should the part where no other offense is stated, where no other penalty is stated in the same clause that creates the offense. All right, so 29, this is one where we did receive, or the committee rather did receive several submissions that need to be looked at. So Jambar and the Lawyers Christian Fellowship recommended that it's not appropriate for guidance on the treatment of items subject to legal professional privilege to be left to a justice of the peace. And Jambar also stated that the courts had mandated that such guidance should be clearly stated in legislation. Subject to the Attorney General's chambers and the Chief Parliamentary Council, however, the technical team believes that the regime in the bill surrounding the protection of legal professional privilege appears to be adequate. It also appears to fulfill the requirements of the judgment that was referenced. And that judgment was the one involving Jambar and the General Legal Counsel's, and the POCA requirements. If you may recall, I'm trying to go over to, right. And Jambar indicated that they believe that more detail would need to be given in the legislation.
Thanks, Ms. Stacey. Would CPC like to come in, or the AG's chambers to come in just to share a bit more about the assurances that they have referred to in their response? Given that you have said that the response is that there's sufficient protection of legal professional privilege in the bill, and that the bill also fulfills the requirements of the judgment. Perhaps they could share just a bit more so that all members of the committee are clear.
All right, let me.
Or yourself, if you have already pulled that information together, of course. Thank you.
Referring to me, Minister, or to CPC and AG? Should
well,
I?
CPC and AG could come in, but I noticed you were pulling for papers. So if you had the answer already, I was happy for you to proceed.
Okay. Well, basically, the judgment only said that the simple question, right? So the Court of Appeal reviewed the regime in that case and observed that the protection of legal professional privilege should not be left to chance or the women fancy of a competent authority, whether that may be concluded a proper mechanism for the greater protection of the LPP must, whoever that may be, concluded a proper mechanism for the greater protection of LPP. It must be designed so that it can be insulated from overreach by whoever is the competent authority. And so they went on to say that the Court of Appeal decision emphasized the importance of clear statutory guidelines and that it should include clear language that prohibits the copying and seizure of the items, for instance, and it should make clear provision, whether in the Principal Act and/or regulations, to adequately and effectively protect the privilege, including judicial intervention by a parish court or judge of the Supreme Court. And it should make clear provision for the privilege to be claimed. In the technical teams, the technical team believes that these are already stated within the bill. However, Section 58.3 of the NIDS from 2017 did make specific provision that says the constable will not be able to copy or seize any item subject to the legal professional privilege. I don't know if that would perhaps be a better or a more adequate or a more palatable representation for JAMBAR and the LCF. And again, we'd ask the Attorney General's Chambers and the Chief Parliamentary Counsel about whether or not we would need to insert anything else.
Thanks, Ms. Facey. CPC or AGC, are you? I actually can't see any hands on my screen, which is sort of taken up with the shared screen.
Oh.
So if you could just indicate, let me see if I can bring this down, if it will help. Nope.
No, I don't see anyone raising their hand either.
But is CPC on?
Yes, I see her name.
Okay. Yes, I am on, Minister.
Oh, morning, Madam CPC. Could you just let us know your view? And I see, in light of Ms. Facey having stated, I know that 29.3 has a broad exclusion of matters subject to legal professional privilege, but the Bar Association's concern appeared to be specifically in relation to 29.2c, which asks the Justice of the Peace to include directions, and they thought that perhaps that was not the best approach. Could you maybe give some greater assurance around the drafting here, or indicate whether there's been any further thought on how to treat with this clause?
Well, Chair, their view was, if I understand it correctly, was that there should be some specific provisions set out as to how to deal with the documents. But I'm not sure that that is something that could be done, bearing in mind that really the intention here is for the directions to be case specific. So I think that this method would allow for that, and I'm not sure why it is that the Bar Association would think that the issuing of directions by a judge might not be the best way to deal with it.
Is it bad, Judge? The warrant is bad. I just submit. Is it?
Yes, sorry. Yes, Senator. So yes, they did suggest that it might be more appropriate to have it dealt with by a judge instead of a parish court judge instead of a justice of the peace, and I have no difficulty with that. So the committee could consider that.
Or the alternative would be for the warrant to be, because most warrants that I have seen the Jamaica Constabulary using are basically almost prescribed standard form warrants, and they fill in the blank spaces in respect to name, address. That's about it. But they would have the warrants being a prescribed form and stating under which legislation it is issued. So I don't know if that, I don't know if it's a policy position why it is a justice of the peace. If it is not, then I don't have a problem with a judge. But if it is a justice of the peace and we're going to use a prescribed form, which would set out the parameters in relation to or what we would expect to be included under 29(2)(c), if that would cover the situation. Just a suggestion in light of what I've seen in practice in relation to warrants that are being used by the Jamaica Constabulary. But if it's not a policy position and we are going to change the justice of the peace to a judge of the parish court in keeping with what the JBA and Legal Adult Association connected to the legal fraternities requesting, I don't have a problem with that either.
I think the query might be if you're applying to a JP for a warrant, so maybe from a practical perspective, how would you then include directions from a judge? Is it that we would then be changing the whole process, that you would now have to go to a judge for a warrant, which would certainly change the efficiency significantly? Well,
under the, let us use the Law Reform Fraudulent Transactions Act. There is a warrant that is used by the JCF. It is in a prescribed form. And it's just the names that are on the address that may be filled in by the Justice of the Peace. But other things may be stated there. Similarly, under the Dangerous Drugs Act, there are warrants that are in prescribed forms and the basic information is included, but they go to specific persons for it. So for example, under the Law Reform Fraudulent Transactions, they do go to a Justice of the Peace. The police just takes the warrant, outlines his reasonable grounds to the Justice of the Peace, and the name of the person is included, JP signs it. So to cover the concern, if we were going to remain with a Justice of the Peace, I believe that the prescribed form would have to state specifically, because the Justice of the Peace may not be of a with the whole requirements of legal professional privilege.
right.
You would have to set out those in the prescribed form that they would be using.
Well, that sounds like an excellent solution, because since 29(3) already says that this clause is not intended to authorize And you're saying that there are forms, warrant forms, which exist, which have specific prescriptions already. And there is an understanding, certainly.
No, what I'm saying is that there are standard forms that are used depending on legislation in relation to the needs. We could probably, if we're going to stick with the justice of the peace, I just say for efficiency, to put the warrant form that will be used in the regulations, and it would set out what the restrictions are that would satisfy the requirements for the protection of legal professional privilege in the warrant.
Yes.
So that is the warrant that would have to be used. It's used in a prescribed form. So
yes,
when
that sounds sensible.
When the JCF goes, or the constable goes to the JP, he's going with a warrant that all that would be needed to be filled in is the name of the person, the address of the particular person, and it can also state what are the items that can be seized, because I noticed that in D, 25(2)D, it does not seem to, unless it is specifically required, it does not require in any general terms. It would have to specifically state cash. Again, that could be covered in a general form to say that what are the items that can be seized. So the police going to a justice of the peace would merely be going there to say that we have reasonable basis for wanting to go to a particular premises to conduct a search and possibly to seize items that are found that would constitute an offense under this act. And he lays out what the basis of his reasonable grounds are, and all that would be required to be filled in is the name of the person and the address of the premises. Because the other conditionalities, which also would cover the legal professional privilege, would already be set out on the warrant. But the warrant would have to be a prescribed form, which is set out in the regulations of this, that would accompany this particular legislation. So they would have to use that specific warrant.
That sounds like a sensible solution to me. I'm interested to hear the views of the committee and, of course, the technical team on that proposal, especially since it is one which Senator Sinclair, you're indicating, is already in use under other targeted legislation. Does the technical team believe, CPC, AGC, that this might be a solution for this provision? I'm not hearing any. Okay.
Chair, through you.
Please.
I agree. I support the proposal of Senator Sinclair. I think it's a workable solution for this particular area of the clause.
Thank you, Minister Smith. Do we have any objections? If I'm not hearing any, then could we note this as the position of the committee?
It's a suggestion coming from me, so I suppose.
Well, I take it that you are in support of your own suggestion, but I can't. The difficulty I'm having, colleagues, is that I'm unable to see anything other than the screen which is being shared. I'm not seeing all the participants. So if someone wants to intervene, please just take the floor and open your camera. And I'm presuming that the screen will open to you.
Minister?
MP Sibley's, please, Member Sibley's,
yes.
Go ahead, morning.
Good morning. My apologies for not being able to put my camera on as I'm driving. I'm in support of what Senator Sinclair recommended.
Excellent. Thanks very much, MP, member rather. And all right, well, if there's no objection from AGC, CPC, then if you believe it's an appropriate solution, then we could note that as a decision here to have a specific prescribed form designed for use, which would include the relevant directions or treatment of items with which are covered by legal professional privilege, noting that 29.3 already provides for this protection, and accordingly, this would comply with the 29.2c. Wouldn't need to be any additional directions because they would already be set out in the form. And that would allow us to keep with the policy direction of allowing for most timely and broad access by use of justices of the peace for this process. So that being the position, and that having been noted, Ms. Facey, would you like to take us? Sorry.
Because I do believe, and well, Minister Chuck is not here, who speaks to the justice of the peace on a very regular basis. And it seems that the task of the justice of the peace is becoming more relevant as we go through our daily lives. And I believe that it is going to require some additional training for them, and for them to be aware that they must start taking and insisting on the police or whoever they interact with for the issuing of warrants and other duties that they perform, that they take copious notes so that they can be available if matters have to go before the court, because this particular provision also allows for a person whose items have been seized to go before a judge to have the item released. And so the basis of the reasonable grounds, I believe, as I said, as a part of their training, justice of the peace must be made aware that they need to start walking with notebooks and take copious notes in respect to the activities and that they perform on our behalf. The other issue that I am raising, which may be just a typo, if you look in 29.4 and 29.5, we refer to a judge of the parish courts. It's pluralized, and I don't know why it is pluralized as against just being a judge of the parish court. Maybe
Seem to be typos, yes. Thank you very much for that. For both for the picking up the typos and for the suggestion. I'm sure Minister Chuck will very much appreciate the reminder regarding training for the justices of the peace and guidance for them, in particular, taking of notes in respect of warrants issued, the basis on which circumstances in which they're approached, time, etc., so that if the matter does have to go before the court, they are well prepared to assist in that regard. So I've taken note of it as well, but I'm sure, of course, Ms. McCarthy has noted as well to remind Minister Chuck. All right, so if there are no other issues on clause 29.
Minister, may I just...
Of course, Member Simmons, go ahead.
Let's train a caution to the wind in light of our recommendation, that which I support. There is a perception, Minister, that comes to me while I'm on the ground, and I'm sure other persons have received this, that at times, notwithstanding the respect that is due to justices of the peace, that the authority named police would sometimes go to persons who they are of the view that will not question or ask certain questions in a manner to satisfy the requirements. And so in that, I am in one with Senator Sinclair that there need to be some serious training of the justice of the peace. And maybe just putting out there, I am going to think it through some more to see what else could be done to ensure that the citizenry will have confidence in our system and in this law.
Thanks very much, member. Your support for the point and your emphasis on why it's important is duly noted for the records. And of course, I'm sure Ms. McCarthy will ensure that Minister Chuck takes that into consideration as well. Very important points. Okay, so if there's nothing further on this, then Ms. Facey, could we move to the next submission under this matrix, please?
Right.
We just dealt with power of search and
Right.
seizure. Mm-hmm.
Well, no, we're still there. Because the constabulary, right, the constabulary force and the Ministry of National Security recommended that the term premises be defined widely in order to also allow for search of items that are found at the premises and not just for the search of the premises. And we had in fact spoken with the CPC about this, and premises would include the appurtenances and the buildings thereon. However, the technical team has no objection to including the searching of items found on the premises as well. Currently, the clause indicates that the constable may apply to a justice of the peace for a warrant to search the premises and seize any item at the premises. So there's nothing in the clause currently which allows them to search the premises. I believe the example search items. I believe the example given was if they found, for instance, a motor vehicle on the premises, they would like to be able to search that as well. So there's no objection to searching any major item found as well.
Okay, that seems like a reasonable request. I would just, because certainly you wouldn't want to have it only, or have their powers of search be limited. I hadn't realized that you would need to say search items as well. I don't know if the draft person, Madam CPC, AGC, are there any concerns regarding the additional clarity or express language, which is being requested by the CPC, by the constabulary? And also, does the committee have any concerns about such a suggestion?
Chair, morning, and morning to the members and colleagues. I apologize for coming on late. We wouldn't have, this is Mardine Aldred, sorry, I'm not able to turn on the camera because I'm having a bandwidth issue.
Morning, SG, welcome.
Thanks, but just to indicate that the chambers wouldn't have a difficulty with allowing for search of equipment, items found on premises. And in fact, there are precedents for that. Sometimes there is a term coined, for instance, there is in, I think, the Farms Act, we talk about the specified equipment to include things like containers, small articles, small areas, that are found on premises. And usually there's also specific reference to searching whether vehicles, vessels. So it depends on what exactly you want to expand it to, but you would need to be very specific to ensure that it's captured and the power is given under the Act. But we wouldn't have any objection to expanding it.
All right, thanks, Madam SG. That is a clear and helpful response. If there are no objections on this matter, we could note this as a decision of the committee to
Chair,
make them. Okay.
Chair,
go ahead.
Before you move on,
go ahead.
I apologize for joining the meeting late. And I do I am sorry to detain it, but what kind of situation is Section 29 expected to meet under this legislation?
Essentially, through you, Chair, essentially any offense under the legislation. So it could be an offense where persons are thought to be, well, since we were just speaking about equipment, thought to be making counterfeit cards or thought to be supplying them, any of those situations, basically the clause says a person is committing or has committed an offense under the act, and they believe evidence of the commission of the offense may be found on the premises. So any of the offenses.
Thank you very much for that explanation.
So the police had then indicated, all right, let's say we go to the premises and the valuable, or rather it's stated here, the item that's likely to be of substantial value to the investigation, they can perhaps see it through the window of the car, but they don't have the authority to search the car, just the premises.
Mm. Right. Yes, it seems very wide, but I appreciate the explanation. Thank you, Ms. Facey.
Okay. Okay. All right. Well, the MNS had another concern because this goes now to, apologies.
Minister, to you.
Okay.
Go ahead, Member Sibley.
I do not wish to detain the discussion, but with regards to the question asked by Member Montley and the answer given, I am a little bit concerned. Is it any offenses? Because there are some offenses that would not require a search warrant or a premises to be searched. That person might be found to be in breach. So I am concerned about that bit, any offense, breach under the act.
Well, I think Member Sibley's, and of course I stand to be guided by the technical team, that the warrant would be issued where a constable has reasonable grounds for suspecting an offense and that evidence of the commission of the offense is to be found on the premises. So that it would, by the very nature of the language, I would imagine you would, the nature of the offense would be one of which you would be able to find evidence. So I'm not sure if you still think that it is too broad. I think the point is just to ensure that you're not so prescriptive about the type of offenses that you're not guided by the issue of evidence, you're guided by a list of offenses. So I didn't read it to be one that's too expansive, but I'm of course open to facilitating the views of the committee on this or the draftspersons. Seems to me that it would be okay.
If that is so, Minister, then I am okay with it based on your explanation, if that is the case. But I thought I heard only just any offense, full stop. So that is why I was concerned. But thank you, Minister.
And Chair, if I may just, I'm sorry to be interrupting so much, but I'm really unclear about this section. Because when you look further, you see that it says that nothing in this section or in a warrant issued under this section shall be construed as authorizing the seizure of anything that contains identity information, if such seizure may be reasonably expected to have a negative impact on any aspect of Jamaica's information communication technology infrastructure. And it just seems to me that is a considerable onus as well as a restriction on what kind might be able to be seized, especially in light of the explanation that Ms. Facey just gave me. It just doesn't seem to, the section just doesn't seem to make more sense to me in that regard, because I would have thought that if you're going after, say, equipment which is designed to create a new identity or a card or so, then for the constable who acting in these circumstances to determine that he can't seize anything that has that negative aspect on the Jamaica's information and communication technology infrastructure, isn't that a little bit onerous, Chair?
What I would ask perhaps is for the technical team to provide us with maybe some examples of the circumstances where one would anticipate 29.3b to come into play. Before Member Scott Motley joined, we had discussed the matter of a prescribed form of warrant, which would be for use specifically under this act, similar to the Lottery Scamming Act and the Dangerous Drugs Act, which have their own specific warrants, which provide the relevant guidance and instructions such that there is clear compliance with the most recent judgments on matters such as these. But on the member's specific question about the breadth of 29.3b, maybe the technical team could share a bit about how that clause is anticipated to work.
And if you'll permit me, Chair, it seems to me that having got the explanation about the breadth, that specific provision then narrows the breadth.
Yes,
if
this
you
is why I've asked them, I do.
Oh, thank you,
I've
Chair.
asked the team to explain how it is intended to work. Perhaps by example, we can get a better understanding. And if it needs to be adjusted, then we can deal with it in that way.
I'm going to ask Mr. Vernon, because it's a technical matter, to provide more explanation as to how the negative impact may take place.
Camila, may I suggest
Oh, welcome back, Minister. Welcome back, Chair. I hope your presentation went well.
So far, I thought so. Thanks. Excellent. But what we'll do, we can recommit this tomorrow or at an appropriate time to give the technical team the opportunity to give us some examples. Would that
I could do that now, Chairman, if you want to.
You want us to do it now?
Yes, Chairman, we could do it now.
Okay, go ahead then, Warren.
And after this point, I will just hand back to you directly, Mr. Chairman. I won't take the floor again.
No problem, Minister Johnson-Smith. Good. Go ahead, Warren.
Okay, thank you, Chairman, and good morning again, everybody. I believe when we discussed this provision, it was specifically, for example, when you look at the government of Jamaica data center, you do have infrastructure in place that may be shared. For example, you may have tax administration, critical systems on the same physical infrastructure, but they are logically separated. You may have other parts of government that may be relying on the entire infrastructure, and you may have a server, critical server, or a switch that law enforcement, for whatever reason, may be interested in investigating. And what you want to do is to try and have a framework around this to prevent the seizure of a critical server that would shut down the entire country, where you could seize a server, and when you seize it, nobody in the tax offices can get any services at all, or nobody will be able to verify their national identification card. So I think it was around that background. If the committee is of the view that there may be a better way to phrase it, we would welcome that, but the intent is to ensure that we have business continuity. And because you would have seen cases where the police go into an entity and they would remove critical servers, but when you have critical servers serving multiple entities, you want to be careful. So it was just around that background. Thank you.
So thank you, Mr. Vernon. Just to clarify then, so if we were to remove the words contains identity information so that the qualification is that there should not seize anything that may be reasonably expected to have a negative impact on Jamaica's ICT infrastructure, which is completely different. And perhaps if it needed narrowing, Jamaica's ICT infrastructure required for the support of the identification, the national identification databases or national identification infrastructure, ICT infrastructure, that perhaps that type of language would allow for the business continuity that you are speaking of and not narrow it in the manner which I think member Scott Motley had indicated might arise. That's the thinking?
Yes, and that would work, Minister, once we can find the language in that.
Our chair might be if something like disrupt would make it a little clearer. I don't know if that's a word which would the drafters would consider appropriate, but it would certainly, in my view, communicate more the mischief which is intended to deal with.
I don't know if CPC, are you on? Did you hear the discussion, CPC? CPC, are you with us? All right, why don't we just put a query beside that particular clause, subclause, you know, to see Senator Scott Motley if we can clear it up. In other words, we will recommit 29(3)(b), you know, when we start to recommit all the clauses that need clarification. Is that okay, Senator Scott Motley?
Mr. Chairman.
Certainly,
Yes.
Chair. Certainly.
Yes, Senator Sinclair.
My colleagues comment in relation to that provision.
Go ahead. We're not hearing the Senator Sinclair.
And the negative impact on any aspect of negative impact or disrupt any aspect of Jamaica's information. I mean, just adding, I see where Senator Scott Motley is, and I was just wondering if you could just expand the provision, leave negative impact, but just add the words or disrupt, or otherwise disrupt any aspect of Jamaica's information. And I suppose you'll cover both scenarios, any scenario at all.
Okay, I think Senator Sinclair, that proposal we could leave with the technical team to work out with CPC. Okay, so when we recommit it, we'll just clarify it, okay? So if that is okay with, if there are no other consideration to clause 29, we could move to clause 30. Kamika?
Pardon me, there was another consideration, right. The JCF noted that clause 29.5 requires that a constable obtain the approval of a judge of the parish court before releasing the item, an item that was seized. And the JCF recommended that this subclause be removed because the approval of a judge to release an item wouldn't be necessary. Under the common law, the constable is under duty to return an item where it's no longer needed for the purpose of the investigation or prosecution of the offense. And in the JCF's opinion, this imposed an unnecessary obligation on the constable to apply and obtain the approval of the judge before releasing the item. So the CPC was consulted And the technical team is in agreement with her that there is no need for modification of the clause because each subclause speaks to a different situation. So under subclause 29.4, the approval of the judge is required because the application is at the instance of the person from whom the item was seized. Whereas under clause 29.5, release could be to a person other than the person from whom the item was seized if that person appears to be lawfully entitled to the item. And because it's potentially a contentious matter, requiring the approval of the judge would provide a layer of protection to the state.
Okay.
So we don't recommend.
Colleagues, I see no problem with that recommendation from the secretary, mid-secretary. Colleagues, colleague have any other concerns with the recommendation? That is to keep the clause.
Right.
So if colleagues don't have a concern, remember the JCF is asking for its removal because they say the common law would take care of it. But the NITS team is saying, no, leave it just because it could be contentious. It makes sense for a judge to approve the release.
I agree. There's nothing lost, Mr. Chairman. If the constable figures he doesn't have any basis to keep it, he can return it.
Right.
But if contention arises because the provision says a constable may, so it's not that he shall go to a judge.
Exactly, Senator Sinclair. So the JCF, if there are no problems, release it. But if there's a problem, then the judge may have to come in. So we can move on. Thanks, Ms. Kamika.
Okay, so 29, just one final one, 29.2D, and this is particularly because we have, the committee has indicated that a prescribed form should be used. The police, the MNS requested that the words describe in general terms the kinds of items authorized to be seized should be removed because it limits the flexibility of the police in executing the search and seizure. But the CPC and the technical team do not believe that there is a need to remove these words. They don't serve to limit the flexibility of the police. And in fact, they may serve to give them more flexibility because it's description in general terms of the categories of the kinds of items. However, given that we will, or we may now be going towards a prescribed form, just wanted to ascertain from the committee their thoughts on 29.2D.
I don't see difficulty, making it clear what the, how the warrant should be executed. Do the technical team thinks that it is restricted?
No, we don't believe that a description in general terms of the kinds of items authorized to be seized is restrictive at all.
Right. The concern I think the JCF may have is suppose they have additional items that they discover.
Sorry, you went away a while ago.
Could they also seize the laptop? You see the point?
No, we didn't. Well, I didn't hear you after the JCF.
No,
words, the JCF.
If you start to state what must be seized, you may well restrict the constabulary force from seizing other items which may appear to be illegally retained. So you might say that laptops should be seized, but then they might see dozens of cell phones inside the property. Would that restrict them from seizing the cell phones?
Sorry, excuse me, Chair. This is Marlene Aldred again.
Yes,
the chambers, we support the inclusion of the words describe in general terms the kinds of items. When it says general terms, you perhaps would not say laptops. You're going to seize laptops. You would use something a more descriptive word to include items that are technology based, for instance. But this is a safeguard. You don't want this provision to be abused. It's not to be just there for a fishing expedition. The police are supposed to have a general idea of what they're going on there on the premises to do and what they think is there, because remember, this is based on the fact that they have reasonable grounds to suspect that a person is committing an offense, and further that they also think that there would be evidence of the commission of the offense on the premises, and that is what they're going to seize. So there has to be some sort of descriptor about what they think is there and what they want to seize. So we would not want these words to be removed.
All right, thanks, SJ. I understand that once the terms are general, so that they're really seized within the context of what they went there for, but also limit them to, say, technological equipment. All right, is there no other concerns with clause 29? Any other, Ms. Facey?
No, Chair, those were the concerns with clause 29.
And they have been dealt with. Okay.
Right. The concerns with clause 30, again, there was only really one concern, and that was the BOJ and several other persons, persons who called in, who wrote in, and other not as substantive submissions that the committee received, where this particular penalty for breaching the secrecy and confidentiality clause, rather duty, it was thought that it was too low, and therefore that offense and penalty regime that will be considered as a whole. That was the sole concern with regard to this clause.
Yes, I think a number of persons recommended that subclause 2, the penalty should be increased to 5 million, consistent with the sort of maximum in the parish courts. Is that correct?
More than 5 million in some instances.
Okay, but if it's more than, but you see, before a parish court, there's a limitation of the
right,
law.
but the person suggested that for BOJ, for instance, suggested that it be a custodial sentence as well. So, and they also suggested that Supreme Court, the Circuit Court, recourse be had to the Circuit Court and not only the Parish Court because of the gravity and the nature of the type of offense. In fact, one person suggested 50 years imprisonment.
Oh no.
Yeah.
So what we're going to do, because there was a major concern from many of the contributors about the deterrent effect of the penalties, we're going to ask CPC to add, maybe to increase in the parish court, so fine not exceeding 5 million, for example, and in appropriate cases to the circuit court. CPC would know to put that. Okay.
Okay,
or
sir.
Aggravated cases or to the circuit court. So that would conclude the concernings of clause 30.
Okay,
So,
Sorry, excuse me, Chairman. Sorry. But when you're giving the jurisdiction to the circuit court, because the circuit court has unlimited jurisdiction, we don't usually indicate the fine. We usually just say to a fine. But
right.
if there's going to be a custodial sentence, normally you have to put that in the maximum.
Right. So that's what I was saying. SG.
But CPC can't make it up though. She wouldn't know what to put in terms of if you're going to have a custodial.
So what I'm suggesting is to increase before a parish court of fine not exceeding 5 million, or to the circuit court for imprisonment or fine. Would that be okay?
Right, but you would need to know what the custodial sentence is for the circuit court, whether it's 3 years, 5 years, whatever it is. Usually we have to put that. The legislature usually indicates the maximum.
Colleagues, any recommendation? Senator Scott Motley, what would be your imprisonment not exceeding Senator Sinclair sentence for monthly.
I'm going to ask a question before I make any recommendation. Under the Official Secrets Act, is there an imprisonment provision?
Do you recall, SG?
No, I'd have to look back at the, remember, those acts are old. They are 1911 and I think amended in 1920 something. But I can.
Why I ask really is because to include it, you may then be having something that appears to be somewhat inconsistent, unless we're going to be looking at amending that act too. But that was just.
But can I say though, Senator Sinclair, there are secrecy provisions in other acts that carry both fine and a custodial sentence.
Okay.
But I did notice this one doesn't have that.
Okay. All right.
And in fact, in fact, this $3 million is higher than many others. Some of them usually just have $1 million. So the fine is higher here, but most of them will have fine or custodial, like so $1 million or a year.
I appreciate it. Well, I don't have a problem. In fact, in my notes that I have on this draft bill that I have here, I had written beside it imprisonment when I saw that it did not include it. But so I have no problem with it. In respect to time, can you suggest what the time in the other legislation that you have made reference to is?
If you can just give me 5 minutes, so if perhaps you could go to another class, so I can give you specific concrete examples. I prefer to find them and just read them.
Okay, no problem. Okay, no problem, SG. Colleagues will come back to it when SG has checked on it. So we could go to clause 31.
Chair, just for clarification, is it then that you will not be considering all the offenses and penalties as a whole?
But in the specific one, you want to add to the circuit court for a fine or custodial sentence.
All right.
Yeah. So once it goes to the circuit court, then we start to look at unlimited fine or a custodial sentence, and we're going to hear from the SG what would be the maximum for that custodial sentence. Okay.
Very well, Chair. Thank you. My apologies. There was indeed another submission under clause 30. The JCF recommended that the words "under any other law" be inserted at the end of this clause, as there may be other legislation which mandates disclosure in certain circumstances. Now, as it relates to identity information, this isn't necessary, as the bill specifically recognizes within its framework the fact that there may be other laws which mandate the authority to disclose identity information. But it's the clause here, though, is not restricted to identity information. It speaks to any information, and therefore reference is made to the Chief Parliamentary Council as to whether this modification would be necessary in relation to information about an enrolled individual, which was communicated in the course of the administration of the Act, but which doesn't fall within the category of identity information. Out of an abundance, this point was raised. Sir, you were saying?
You broke up.
Right. No, I was just saying that initially we had agreed that it wasn't necessary. However, after looking back at it, realized that it's not restricted to identity information solely. And therefore there may be a bit of there may be some room there, and it may need to be addressed. And that is why we're bringing that to the committee's attention.
So the recommendation is to add "or any other law" at the end of clause 31B. 31.
Subject to, right, yes, Chair. Subject to the Chief Parliamentary Council's guidance on this matter.
CPC, were you able to Or can you respond to that now, or you want to give it further consideration?
Well, it's really a question of whether policy, whether it is that you want this an absolute provision for secrecy, save and except the provisions for disclosure of identity information, which is allowed under 24, or if there are some other opportunities under any other law which might provide or which might require this provision to speak to disclosure.
The NID Secretariat, what's your recommendation, by the way? Do we accept the JCF recommendation or not?
Well, this was a clause. This particular term gave the committee, well, the committee seemed very uncomfortable with this particular inclusion. However, no, the team doesn't believe that it's necessary to insert it here.
All right.
No, we don't believe that it's necessary to insert it here. However, we will look back at it, and if required, we will ask that it be recommitted.
All right, no. In fact, we're going to ask that it be recommitted when we look at it again tomorrow or next week, so that members of the committee can get the opportunity to look at it and think about it, and also for the NIDS team to give us a firmer recommendation. Okay, so put 30 will be recommitted for that also. Okay.
All right, thank you, Chair.
All right. 31.
As it relates to protection from liability, the MNS indicated that consideration should be given to defining who is an officer of the authority, because they noted that generally in other recent legislation, the term officer, when used, is defined. And we had spoken with the Chief Parliamentary Counsel regarding same, and her indication was that it would flow from the first schedule where the chief, which spoke to the national ID, part 1 of the first schedule rather, which spoke to the chief executive officer and other employees. In light of the fact, however, that the governance structure is being revised, it was thought that it may be necessary to alert the committee to this particular recommendation.
So you need a decision on this.
Right.
And here again, you know, the committee always want to ask the NID Secretariat who have studied this, what's your recommendation?
Well, we don't believe that a definition is necessary.
And what was the CPC's? Judith,
as the bill stands, right?
Well, Chair, my advice initially was that it was covered based on what was set out in the schedule. I don't expect that to change, even with the changes in the governance structure. But depending on how that is set out, then I would adjust the language appropriately, because then it would just be a wording issue. So I don't think we need to be detained.
Right. All right. If the schedule is sufficiently clear, then we should have no problem with the clause. Is that so, Judith?
Right, Chair. I mean, if the schedule refers to them as officers, then it would remain as officers. If we speak about employees, then I would change it to refer to employees.
Yes, colleagues, I don't see the need to really define the officer in the bill itself, since in the regulations it can be dealt with. So that is so we could adopt clause 31 as is. Okay. Very
well, Chair. The imposition of fees, the Ministry of National Security recommended that the reference to clause 16.6, which is an instance where fees are not imposed, should be inserted, and the technical team recommends same. Norman Manley Law School recommended a minimum list of services should be free of charge, and the technical team believes that this is an administrative matter, stated in regulations, the bill already indicates 2 instances where no fees will be charged. We had consulted with the CPC regarding the inclusion of that reference, and I believe that that was accepted.
CPC, your OFA as to how we include that clause. Okay.
Sorry, I didn't hear the last part of what Ms. Davis said.
Right. So there were two instances where the bill spoke to no fee being imposed, and in 32, it states except as provided in section 10.6. So there's no reference to the other instance at section 16.6,
yes.
right? Yeah,
yes, so we would just add a reference to 16.6.
Right. Yeah.
Okay.
All right.
Thanks again, CPC. So basically, we can sign off on 32.
Right, sir.
With that subject to that addition. Okay, 33.
Right. Now, BOJ recommended that subclause 2, this is a regulation making clause, and BOJ recommended that subclause 2 should refer to how to destroy identity information where the enrollment of the individual is canceled pursuant to section 14 of the bill. The technical team doesn't believe it's necessary to specify this, as clause 33.2M empowers the authority to make regulations for any other matter that prescription is required. The Love March movement, though, opined that there is a requirement for the regulations made to be preceded by parliamentary debate, wide-ranging stakeholder consultation, or similar public town halls as have been conducted for the Act. The technical team takes the opportunity, because there were other individuals or other submissions made, which made it clear that the fact that the bill states the regulations are subject to affirmative resolution, persons didn't understand that affirmative resolution is actually parliamentary scrutiny. So the technical team takes the opportunity to make reference to clause 33.3 that states that the regulations are subject to affirmative resolution, and that means that the regulations will be laid in both houses of parliament and must be scrutinized and affirmed by both houses of parliament before they become law.
To the best of my knowledge, this NITS team has a draft of the regulation.
Well, we are drafting, yes, sir.
Is there any likelihood when the report is prepared that the regulations can also be shown to the Joint Select Committee, so we can at least have initial examination of it, so that we can look at the regulations and the report, for both the report and the regulations to be tabled in Parliament at the same time? Is that possible?
Working towards that, Minister.
No, I need a confirmation, because what we would want to say, you see, is that the NITS team would like to examine the regulations, you know, what you have at least, and then the report at the same time, so we can effectively sign off on the draft regulations and the report for Parliament to adopt them. So that is, so is that possible?
I believe it is, Minister.
Right, okay, so basically then we're saying—
all things being equal.
Right, so we're saying for clause 33, colleagues, we're hoping that once we have finished the clause by clause discussion and adoption, we're going to ask the NITS team working with the parliamentary secretariat to prepare the report, but the NITS team to also have a draft set of regulations for the Joint Select Committee to examine, which we're looking at hopefully before the middle of June. Okay?
Very well.
So that we can hopefully, once we sign off, we can table the report and the draft regulations sometime in June. Okay?
Very well, Minister.
All right, so if that is so, we could move from 33.
Right.
And 34 and 35 are basically straightforward.
Right, so my apologies. 34, there was no comment made there. 35, the there were two major comments, and the Jamaica Government Pensioners Association recommended that the act go even further than requiring a review 3 years after commencement, and also required that the fines and penalties of the legislation be reviewed every fixed number of years. The committee may wish to consider this recommendation, as it would serve to ensure that the penalties remain in keeping with prevailing economic realities over time without requiring an extensive and comprehensive review of the legislation.
But if it is reviewed after 3 years, then at that time we can make such determination.
Yes. So what JGPA is saying is that notwithstanding that 3-year review, the fines and penalties could be reviewed every so often additionally.
I don't know if that is, but what I'm saying is that needed? Because after 3 years, we could consider, the penalties and determine then and there whether the review of the penalties should take place every 3 years, as the case may be.
Okay.
Right?
Yes, we could do that, sir. So yes.
Right.
Agreed.
So we're saying in relation to 35 that the operation of the act and also the penalties should be reviewed every 3 years. At least after 3 years. And when it is reviewed, that joint select committee and Parliament can decide whether you continue to review it every 3 years. You see the point?
Yes, sir.
Okay. So if that is okay, colleagues, we can move on from 35 to 36.
Very well. Right. With regard to the transitional clause, this is the usual transitional clause. However, whenever a new entity is being introduced or is being introduced from the closure of another entity, and the Jamaica Civil Service Association highlighted a concern that the section is similar in wording to that of the Tax Administration of Jamaica Act 2013, and that act caused a lot of disagreement with the JCSA to the point that industrial action was taken. The problem arose from the application of the secondment provision, which saw staff acting in excess of the time specified in the act, notwithstanding that there were no special circumstances. Now, the law, the response from the technical team is that the law may only ensure that an enabling framework exists. The application, which was referred to by the JCSA, of that law is really an administrative issue. The legislation shouldn't be modified to accommodate this recommendation. The recommendation was an application of a GOJ change management policy to guide how staff are to be treated in transition arrangements. So the law shouldn't be modified to accommodate that, particularly as that is a policy document which can change from time to time. And the fact that it's a policy document also strengthens the fact that it's really an administrative issue, which speaks to the application of the law and not necessarily an issue to be corrected within the law itself. So we would not suggest that.
You don't say they need to add or modify clause 36.
No.
So
no, Chair.
So if that is so, colleagues, we can move for the adoption of 36. And it seems to me 37 and 38 are fairly straightforward. Is that
Yes.
so? So unless colleagues want us to, any concerns with those clauses, we can go back to 20 to 30. I don't know if SG is ready.
Yes, Chair. As it relates to the penalties, under the Data Protection Act, that's section 66. Similar offense before the parish court, it's 2 million or 2 years, and circuit court, it's a fine or 10 years. Under the Integrity Commission Act, section 56, parish court, 1 million or 1 year. Under the Revenue Administration Act, section 17, big H, parish court, 1 million 9 months. And then you have under the Banking Services Act, They have two regimes. So if you go to court, parish court, it's 5 million or 1 year. Supreme Court, a fine or 5 years. But they also have a fixed penalty regime, which would be $7.5 million.
All right. May I suggest to the team that we look overall at the penalties for offenses, and Mr. Vernon, and work with CPC, so we identify the clauses in which we want a sort of the demand, or the, should I say, the expression from most of the contributors is that we need to have higher fines or higher penalties. So what we're going to do is to ask the technical team to examine all the different offenses in this act and to make some recommendations first thing tomorrow morning as to the offenses, the various offenses and the appropriate penalties, rather than trying to sort them out at this time. So would that be okay, Ms. Spacey, for you to look at all the different clauses where a penalty is to be imposed, and we can consistently say that the penalty should be X million dollars or X million or imprisonment, as the case may be, including this section 32. Okay? So
very well, Chair.
We have a sort of not necessarily similar, but some consistency, so that it can be approved without any more when it goes back to Parliament. So we do that first thing tomorrow morning, and then apart from that, I'm going to ask you, Ms. Spacey, to circulate, ask the Secretary to circulate the 38 clauses, save and accept those that deal with governance, where we have signed off, and also those which are to be recommitted for further for signing off. I know I'm sure there are about 6 to 10 clauses that have to be recommitted. Okay?
Right, Chair.
So what I'm suggesting, colleagues, is that for tomorrow morning, first thing we deal with are the penalties. And secondly, we then look at all the clauses that must be recommitted. So we're going to ask you, Ms. Spacey, to tell the Secretary to circulate a list of 1 to 38. You exclude those that say governance. And from the 1 to 38, you tick those that have been adopted, and then you put those which are to be recommitted to be signed off by the committee tomorrow. That will not stop members of the committee, even if we have signed off, to ask that they be recommitted. So what I really say to members of the committee, tomorrow as we sign off, any particular clause that is given difficulty or you have concern about, please indicate at the outset tomorrow morning so we can examine them. Is that okay, colleagues? So Ms. Spacey and the Secretariat, we're asking for an email today so we know what has happened in all 38 clauses. All right?
Very well, Chair.
We'll also give some indication of what the governance structure could look like, so that next week, if we still have some clauses to be examined next week, fine, we will do so. But if we have signed off on those that we have recommitted, then next week we will be just looking at the governance structure and those clauses that deal with the governance structure. Okay?
Very well, Chair.
All right. So if that is so, I know the Secretary was asked to be released around now, because I think there's another committee meeting at 10. So colleagues, if there are no further concerns this morning, Senator Secretary, you wanted to raise
a quick one. When we were dealing with 32,
yes,
the imposition of fees, 32, you had mentioned that it refers, as it is drafted now, it refers to section 10.6, but you had indicated that there would be a reference to a 6, what was it, other?
Yes.
16.6.
16.6.
Right.
That will be added, I think.
Yes, but didn't we all let me just quickly look and see, because probably I may be a little out. 16.6.
Page 22 of the bill.
Yes.
No, I think
What didn't we say that in the replacement shall not be subject to fee payable? 18, when we're doing 18.3, didn't we say that the replacement, or did we cover it? 18.3, where there will be a renewal because of time.
no.
Oh, yours.
Didn't we have that as saying that there will be no fee imposed?
No, that's my understanding too.
Yeah.
The renewal will not.
Right. But, and I think we had agreed that there would be a provision or 18.3 to say that at no charge or something to that effect will be renewed without charge. So that means that 32 would have to make reference to 18.3. Did we agree on 18.3 saying that it would be without charge?
That was agreed.
Chair?
Yes.
If I may, my recollection was that this particular fee would be dealt with in regulations, and there a statement would have been made that no fee would have been charged, but that would leave it open maybe at some later stage if expenses mode for a fee to then be imposed for renewals. That was my recollection of how it was treated.
I think the position, as most persons understood it, is that once once the card is being provided initially and also renewed at certain periodic times, that there should be no imposition of a fee. I think that's what Senator Sinclair is.
Yes, that is it. But I think Ms. Grant is correct in that we had said that would have been stated in the regulations and not in the act.
Right. Well, that is why.
Remember, I'm a little up in age, Mr. Chair.
No, let's understand. That's why I'm saying we need to have a look at the regulations so we can look at the regulations and the final report to Parliament around the same time to sign off and vote. Yes. That's why we have indicated that from the beginning, reiterated it now. And so when the report comes, we want the draft regulations to be a part of it, okay? So with that said, can we ask for motion of adjournment? And we meet tomorrow at 8:30 and we examine first the penalties, and then we recommit as many of the clauses as we can and to sign off on the clauses. So Senator Sinclair, move for the adjournment.
Also move for the adjournment, Mr. Chairman.
Seconded by Senator Camina Johnson-Smith. All right, thanks again, everyone. Promptly again at 8:30 in the morning.
Thank you, Chair.
All right, Chairman.
Trying to reschedule